Hello friends. Recently in the budget speech of Honorable Finance Minister Srimati Nirmala Sitharaman had announced that the decriminalisation process of Companies Act has been completed and now the government proposes to decriminalise the LLP Act 2008. Friends, recently Company Law Committee had submitted its report on 4th January 2021, wherein the committee had suggested the decriminalisation of 12 compoundable offences under the LLP Act. The above proposal of Finance Minister is based on this report of the Company Law Committee. The object of this relaxation scheme is to encourage the startups and remove the fear of criminal and other liability from the minds of the entrepreneurs on the first hand, and on the other to reduce the cost of compliance for the small ventures. Also to provide the ease of doing business. The government treats the honest and ethical corporate entrepreneurs as the wealth creators and recognize them as national builder. So any violation of compliance which do not harm the public interest without any malified intention need to be decriminalized. Friends, as we all know that limited liability partnership is a hybrid entity which enjoys the advantages of corporate entity and also privileges of lesser compliances burden and is a tax efficient. LLP is not subject to dividend distribution tax and CSR. The key objective based on which the Company Law Committee proposed the relaxations and the basis on which the government is proposed to amend the LLP Act are: number 1, to provide ease; number 2, to reduce compliance cost; number 3, to shift the judicial process to the in-house adjudication mechanism and unique system to be introduced by the government. As per proposed system of in-house adjudication mechanism, Company Law Committee had proposed 12 offences under the Limited Liability Act which need to be decriminalised. These offences are prescribed in Section 7, 8, 9 and 10 relating to designated partners, their liabilities and reporting requirements. Section 13 relating to registered office and change therein and compliance required. Section 17 and 21 relating to change of name of LLP and compliance publication of LLP name in various correspondence. Section 25 change in designated partner and reporting thereof. Section 34 and 35 maintenance of books of accounts, audit and filing of statements to the registrar within prescribed time. Section 60 compliance in relation to compromise and arrangement. Section 62 non-filing of order of tribunal. Further, Section 73 relating to non-compliance of the order of tribunal has been omitted. In addition to above relaxation, Company Law Committee also recommended for introduction of certain new concepts under the LLP Act to provide ease and promote the incorporation of LLP and startups. First one is small LLP. Similarly as the small companies, the concept of small LLPs to be introduced. These small LLPs would be subject to lesser compliances with lesser cost of compliances. Also, it is proposed that the LLP may also issue non-convertible debentures. This will help the capitalization of LLPs. Also very important, to reduce the burden of cost of compliance from the LLPs. It is proposed to reduce the additional fees from existing ₹100 per day. Friends, all these relaxations are going to not only reduce the compliance but the cost of compliance will also be reduced. All these relaxation will promote the startups and boost their morale. Thank you friends for watching this video. This video is brought to you by SSAS and Associates LLP.